Good morning to all of you. Welcome to legal ethics class or a professional ethics class. Friends, we are going to discuss the duties of the advocate towards the client. Towards the client. In these duties, I told you that the advocate should not go on strike. Of course, it is a much debatable subject. I don't want to go too deep into the matter. So, basing on the judgment given by Honorable Supreme Court of India in the case of ex-captain Harish K. Uppal versus Bar Council of India, later it has become Union of India. So, Harish Uppal case. So, Supreme Court clearly stated that you are bound to attend the court on the dates of adjournment when you take the brief. If you go to Rule 11, Rule 12, it means the same. You have to attend the court. Of course, there is a leverage also. If you are not able to attend the court, you have to send a proxy. You cannot avoid the adjournments. You cannot avoid going to the court on the date of arguments. If you do like this, it is nothing but the so-called professional misconduct. So, in the name of strike, already I told you the case, classic case, that is UP Sales Tax Association versus Tax Bar Association 1996, where the advocate Ramchandra Gupta, he has attended before the court with wearing a pistol, loaded pistol, and it was highly deprecated even by the Supreme Court of India also. Right. Now the issue is whether the advocates have got a right to go on strike or not. Of course, simply to say no. But if you ask any bar association member or any advocate, what he will say? We are an association. So as per the Constitution, Article 19 deals with the association. This association is a registered one. Whenever any public grievance is there, whenever any grievance relating to the lawyers is there, definitely we have got a right to go on strike. Suppose if we don't go on strike, who else is going? So, ప్రజల సమస్యలను వినిపించే మేమే స్ట్రైక్లు వెళ్ళకపోతే మామూలు మనుషులు వెళతారా అనేటువంటి భావన కూడా ఉంటుంది. దట్స్ వై ఐ టోల్డ్ యూ దట్ ఇట్స్ ఏ మచ్ డిబేటబుల్ సబ్జెక్ట్. బట్ ప్లీజ్ రిమెంబర్, యాజ్ స్టూడెంట్స్ యూ హ్యావ్ టు అండర్స్టాండ్ దట్ యూ షుడ్ నాట్ గో ఆన్ స్ట్రైక్. ఏమవుతుంది అనేటువంటిది క్లాసిక్ కేస్. ప్రీవియస్లో ఆల్సో వీ డిస్కస్డ్ స్ట్రైక్ బై ఒరిస్సా అడ్వకేట్స్. రీజన్, they wanted a special bench at Sambalpur. For that, the state of Odisha lawyers, they have been going on strike for the last 1 year. Last month, it has come to the notice of the Supreme Court that during the agitation, they have damaged the CCTV footage, the so-called session judge's office and other things. It has taken a very serious issue and they have issued contempt notices. Of course, the contemners, that is the advocates, they have appeared before the court and they have tendered unconditional apology. But when the matter came before the Supreme Court of India, so you can read the cases Messrs. PLR Projects Private Limited versus Mahanadi Coalfields Limited and others. Actually, this is the regular case. In this case, the issue of lawyers' strike has come to notice. So, advocate on behalf of the so-called contemners, he requested the court to close the contempt proceedings because they have tendered apology. You can read the case in diary number 33859 by 2022. But please remember, the bench consisting of Justice Sanjay Kishan Kaul and Manoj Mishra, they refused to close the contempt proceedings against the lawyers because what they have done? They have indulged in vandalism during the strike. And actually, the advocate Vijay Hansaria, so he requested the court, Your Honor, Milord, already they have tendered the unconditional apology. Therefore, please close it because when once you take up the contempt proceedings, if they are suspended from practice, they cannot attend the court. Is it not? The cause for the strike is for a bench at Sambalpur, High Court bench at Sambalpur. It's a reasonable cause. But of course, they apologize that they have continued the strike for about 1 year or so. But here, Honorable Sanjay Krishna Kaul, he stated that I am not impressed because the apology was intended actually to wiggle out of the uncomfortable situation. So since the contempt proceedings were taken up, then only they have come to the right way. So is the apology coming from his mind or not? This is what I told in Nandalal Badwani's case. First case, Nandalal Badwani, where he actually commented adversely on the judge, and he said the ADJ called him and effected compromise, and he has submitted the apology, but the apology is not wholehearted. That's why the matter was taken away. He was suspended for 5 years. Likewise, here also, please remember, the apology, did it come from heart or only just to avoid the uncomfortable situation? Of course, here Orissa High Court, they also say that, Orissa government also says that, Your Honor, you may impose certain conditions, just like our anticipatory bail. So you may pass some directions stating that the advocates will take an undertaking that they will not go on strike, because there should be some end to the impasse, because clients are getting so much of worry. They are getting worried because the cases are not going on. So let us see what will happen in the Supreme Court. Of course, Supreme Court refused to consider the apology at present, and at the same time, it has directed the Bar Council of India to continue its inquiry. You may be knowing, according to Section 9 of the Advocates Act, Bar Council of India will have the disciplinary committees to inquire into the professional misconduct cases as per Section 35. Of course, they can reprimand, they can suspend, they can remove him. So that process will go on, but at the same time, as regards the contempts, Supreme Court will have a ruling into the matter. At present, they are not going to take up anything. So this is the situation at present. So to conclude, I advise, as advocates, young budding advocates, don't go on strikes. This is the advice I can give you. With this, I am concluding. Thank you very much.